the moderator of this panel today. So let me just give you a little background on how we came up with the panel. I would like to present you the panelists and a few words on house rules, so how we are going to spend together the next hour and a bit. So the idea of this panel stems from a project, a Horizon project called HEROES, which stands for Novel Strategies to Fight Child Sexual Abuse and Human Trafficking Crimes and Protect Their Victims. So HEROES is an innovation action structured to support stakeholders who work against these crimes from three main perspectives: so prevention, investigation, and victim assistance. HEROES essentially develops technological tools to address these crimes, and the tools will serve two main purposes. So they will raise public awareness with regard to trafficking in human beings, child sexual abuse, and child sexual exploitation. And second, they will support different stakeholders to be engaged in addressing these crimes, right? This is basically very, very short on the project. So the project is lasts more than 3 years, so you are very much encouraged to follow on social media and look on the website of the project. A little bit on the consortium. So we are 25 partners from 17 countries and 3 continents. On another classification, we are a group which is comprised of universities, research and private entities, NGOs, an international organization, a governmental organization, and law enforcement agencies. Now you can follow us on social media, visit the website. Important to say is that the project received funding from the European Union on the Horizon 2020 Research Innovation Program. Also important to mention is that the views presented in this panel do not reflect the European Union's opinions, but rather the authors' points of view. Another important disclaimer, I think it's required when it comes to terminology. You will hear the term victim, and in the anti-trafficking debate, at least this has been contested, and other terms such as survivor are being preferred. But I would like to mention that both terms are correct, and the distinction is how and when they are used. So usually the term survivor relates to the recovery process, while the term victim is used in legal proceedings and are usually referred to criminal justice systems and to the legal status of a person. Another important point refers to child pornography. So material depicting children with sexual content is often referred to child pornography in international and national legislation. However, in the last 5 to 10 years, there is agreement that this connotes legality, and actually it might mask what it really is, so child abuse. So that's why the term child sexual abuse material is used by many stakeholders instead. However, you will be hearing child pornography when it makes sense for a particular national legislation. So that being said, let me move on and introduce the panelists who are here today. They all conducted research within the HEROES project on the legal and social context of child sexual abuse, exploitation, and trafficking in human beings. Margarita Vale is a professor of criminal law at the Department of Procedural and Criminal Law at the Universidad Complutense de Madrid. She is a specialist in criminal law. In her research and work, she addresses issues of legal theory of crime and crimes in particular, specializing on the one hand on the issue of human trafficking and on the other on corruption offenses. Our next panelist is Jimmy Perumadan. She's a researcher at the International Center for Migration Policy Development. She is a colleague of mine. She's been working on EU asylum policies, EU anti-trafficking policies, and labor market integration of female refugees. She holds a master's degree in human rights and democratization, as well as a degree in social and economic sciences. She specialized on international migration law and international refugee law. Nadine El Degmak holds a master's degree in law from the Lebanese University and an LLM degree in international and European law from the Free University Brussels. Currently, Nadine is a PhD candidate at the Free University Brussels and member researcher at the Fundamental Rights Research Center at the VUB. In order to stick to the time allotted to this panel, and please do not exceed 15 minutes. After the presentations, we can take questions in the Q&A sessions. And I encourage all participants to use this function, Q&A function, to write down their questions at any time, and we will address them at the end. Thank you so much. So with that, Margarita, you have the floor. I will stop sharing now so that you can share your screen.
Thank you, Magdalena. I hope my sound is on and everybody can hear me. Thank you, everybody, for joining us in this panel. And as my colleague has said before, I will talk about how to legally address online sexual abuse and exploitation with some examples from the Spanish Criminal Code. Sexual exploitation and abuse of children and adolescents is increasingly taking place on or through the internet. The terminology guidelines for the protection of children from sexual exploitation and sexual abuse, the Luxembourg guidelines, define online sexual exploitation as all acts of a sexually exploitative nature carried out against a child that have, at some stage, a connection to the online environment. It includes any use of ICT that results in sexual exploitation or causes a child to be sexually exploited, or that results in or causes images or other material documenting such sexual exploitation to be produced, bought, sold, possessed, distributed, or transmitted. Until the beginning of the 2000s, the problem of the online children sexual abuse was mostly confined to the production, possession, and distribution online of children sexual abuse material or children sexual exploitation material. However, the dynamic nature of CTES has expanded the notion of internet-facilitated child sexual exploitation to include an evolving range of practices such as live online grooming and online sexual extortion and coercion. Moreover, ICTs are now increasingly being used by a range of exploiters. This includes those who offend children online, as well as offenders who seek offline contact with children using ICTs to connect with and groom them. So what's the difference between pre-2000 behaviors and those that are becoming increasingly common? In the production, possession, and distribution of child sexual abuse material, the child was not engaged in any personal interaction in the ICT environment. The sexual abuse of the child took place physically, and then the exploitation was carried out through ICTs. Nowadays, the internet is not only used to distribute content, but also to take advantage of the constant and regular use of the internet by minors to recruit them through social networks, online games, and live video platforms. The number of children using the internet is growing. There are multiple reasons why children may be attracted to membership of social network. In the slide, you can see a few examples of the advantages of using the internet and social media for children. However, figures on the use of internet by minors show that social networks are the online environments where most sexual solicitation of minors take place. Social network can end up constituting a space in which dangers can lurk for children and adolescent users. Thus, at the same time as it has many advantages, the net has a number of disadvantages that can encourage the commission of crimes on it. Among the disadvantages indicated on the slide, I would like to highlight that the network allows for extending and reducing time, an issue that is relevant in cases of victimization of children online, since even if a child is not connected, potential aggressors can leave messages or gifts that the victim receives when reconnecting. Also, that on the internet, the so-called electronic double works, since the real eye is not shown, but a digital copy that combines circumstances and characteristics that do not necessarily coincide with reality. The most common manipulation in contacts with children is usually the age. The combination of these facilitating factors of criminal behavior online, together with risky behaviors carried out by minors, such as disclosure of unsafe personal information, addiction to social networks, and the observance of risky sexual behaviors, can lead to a process of online sexual solicitation. In this way, it is easy to see that risk on the internet exists for children and adolescents, and given that they have more difficulty than adults in identifying risky behavior, it is easier for them to fall into them. European lawmakers couldn't remain unaware of this growing risk. So the Council of Europe Convention on the Protection of Children Against Sexual Exploitation and Sexual Abuse, or the so-called Lanzarote Convention, included for the first time in 2007 the need to criminalize the conduct of sexual solicitation of a minor, the so-called child grooming. In 2011, with the adoption of Directive 2011/93 EU, European Union member states were urged to include in their legislation not only child grooming, but also conducts known as sexting. The directive in 2011 insisted on the fact that solicitation of children for sexual purpose is a threat with a specific characteristic in the context of internet, as the latter provides unprecedented anonymity to users because they are able to conceal their real identity and personal characteristics such as their age. Europe urged governments to make the appropriate legal reforms. What happened in Spain? Of course, Spain took note of what the European lawmaker said and introduced those two offenses in the criminal code. The acts of child grooming were introduced in 2010, and sexting was introduced in 2015. This slide shows the content of the rule of the Spanish criminal code. Now I will set out the most important elements in relation to each of the actions described. And I will start with the elements that both conducts have in common, child grooming and sexting. Firstly, the criminalization of both types of conducts seeks to protect the same protected legal right, the right of minors not to be involved in a sexual context without validly given consent, while at the same time protecting the formation and development of the minor's personality and sexuality. The aim is to avoid interferences that condition a training process that requires time, which should progressively lead to a situation in which the capacity to decide what one wants or does not want sexually is truly free. Secondly, both conducts must be carried out on a victim under 16 years of age. That's because in Spain, the age at which a minor can freely consent to a sexual relationship is 16 years old. Finally, the contact with a minor under 16 must take place via the internet, telephone, or any other information and communication technology. Now, let's see the difference between both conducts. First, child grooming. We can define, or the Spanish criminal code defines child grooming as the proposing to arrange a meeting with a view to committing a sexual offense. From the first or subsequent contact, there must be a proposal for a physical, not virtual, meeting, which must have been accepted by the child. Insincere proposals, or those that the child has not taken into consideration, will not be relevant. This must be followed by material acts of reproachment. We can understand this rapprochement as an act that goes beyond mere virtual contact. It is not essential for there to be sexual contact, or even for the minor and the subject to meet in person, but the offense is deemed to have been committed when, after contacting the minor and proposing a date, the subject carries out the material acts aimed at approaching with a sexual purpose. All these actions must be carried out with the aim of committing one of the offenses described in Spanish criminal code, such as children's sexual abuse, or all the offenses related to elaborate children's sexual abuse material. Grooming, we can define it as a preparatory act for subsequent offenses against the sexual indemnity of minor. All the elements in this crime must be presented cumulatively, which means that its scope of application is very restricted. As you see, the penalty, you can choose between prison and fine, and it can be aggravated when it's carried out under duress, intimidation, and deception. Sexting can be defined as the acts intended to trick the minor into obtaining or displaying pornographic material. The transposition of this offense from the description contained in the directive has not been entirely satisfactory. Why? Firstly, because the typical verb used in Spanish is confusion. The Spanish word has been used as a poor translation into Spanish of the original soliciting, which means that the spirit of the directive is not the one taken up by the Spanish lawmaker. This verb, that they used in Spanish, means to deceive, taking advantage of the inexperience or candor of the deceived. Conduct substantially similar to that of deception, but with the nuance that is carried out on persons who in some way are understood to be inexperienced or candorous in the sexual sphere. Of course, in this criminal offense, the person who contacts the child will not be punishable under this present if it is the child himself who takes the initiative and sends the visual material. While the directive speaks of the request by an adult, Spanish text does not make this precise definition and can be applied to underage authors. This is highly criticizable since sexting is a common practice among adolescents. Also, the offense in the Spanish criminal code version refers to a minor, so this provision will apply even in the photographs or videos that the perpetrator requests from the groomed minor are not his own, but those of a third party who is not involved in the conversation and the request. The Spanish criminal code also refers to pornographic material, which means that it is not limited to child pornography or child sexual abuse material, or showing pornographic images of minor in general, when the European standard refers exclusively to active subject dropping a minor into providing him or her with child pornography in which the minor is depicted. Lastly, it carries a lower prison sentence than the child grooming. And this could be consistent with the fact that, on one hand, the first paragraph can be a preparatory act not only of an offense related to child pornography, but also of a sexual assault, and on the other hand, that the second paragraph does not require a proposal of an encounter or act materially tending to achieve it, so that its potential harm to the interest of the minor is theoretically lower. Moreover, the penalty for this offense is inconsistent in comparison with the penalty for the offense of child grooming. The penalty for child grooming carries an alternative penalty, imprisonment or fine, while in this case there is no possibility of an alternative. So, as conclusion, we can affirm that online child sexual exploitation that not only start when images of sexual exploitation or abuse are posted on internet. So it is imperative that the legal frameworks describe and punish all possible forms of victimization. Spain has followed the guidelines and recommendation of the European later. And even the Spanish legal framework may present some shortcomings or distortions in relation to the model proposed by Directive 2011/93, it is undoubtedly a robust, specific, and sufficiently broad model to cover all forms and dynamics of online child sexual abuse. Thank you, and I stand here for all your questions. Thank you very much.
Thank you very much, Margarita, for such a comprehensive presentation, for starting with the factors which may lead to child sexual exploitation online, and then moving on to specificities of the Spanish criminal code. Thank you so much. We would like now to move to the next presentation, where Jimmy will continue this discussion, but also will refer to the current EU debate on child's rights versus privacy rights. So Jimmy, the floor is yours.
Thank you, Madalena, and also thanks for the nice introduction at the beginning. I will share my slides with you. Yes. All right. Thanks a lot, and also welcome from my side. And I'm happy to see this great interest in our panel. I'm Jimmy Perumadan. I'm researcher at ICMPD, and I will discuss today research findings that we conducted in the framework of the HEROES project. This research was focusing mainly on overall on the legal framework of online child sexual abuse and online trafficking in human beings. But today I have selected two relevant aspects, which are relevant for the conference, for this conference and for this panel. So I will talk about, on the one hand, the challenges in the legal framework of online child sexual abuse, and also touch upon the current EU policy debate on child rights versus privacy rights. For your information, I have decided to skip my slide on the methodology because the time constraint is just is limited. But if you're interested in that, I'm very happy to clarify on that in the Q&A session afterwards. So, challenges in the legal framework of online child sexual abuse. First of all, I have some general remarks before I go to the challenges. So when discussing technology-facilitated cases of child sexual abuse and exploitation and trafficking in human beings, it is important to highlight that it is rarely a clear cut between online versus offline cases. It can be fully online, but more often it is a mix of online and in-person interaction. Victims may be abused and exploited in multiple ways, as the boundaries between the physical and the digital world is blurring. Also, the line between online and offline abuse and exploitation becomes blurry as well. A concern very specific to online child sexual abuse is also this continuous exploitation that may occur when recordings of the exploitation circulates the web even after the exploitation has ended. So despite the removal of this material from one platform, it might still be available on other platforms and shared with others. For persons depicted on this material, the exploitation never ends. It feels that it never ends, which might lead to re-traumatization. Governments and the international community introduced legislation in the late 90s and early in the millenniums to address the severe human rights violation of children. This effort was made to harmonize legislation, to also facilitate the prosecution of these crimes. However, at that time, legal instruments did not prepare for the future change that sexual child offenses would undergo due to the significant influence of ICT. I have brought two examples on showcasing these new elements of the online dimension. This is on online grooming and secondly on self-generated material. My colleague Margarita has very nicely presented the elements of the criminal offense within the Spanish legal framework. So thanks a lot for this. I will focus only on one element that shows the challenge of this online aspect. So these new elements of criminal offenses related to exploitation arise that are not captured in the existing legislation in some countries. So international as well as existing national legislation on online grooming requires the intention to physically meet a child for sexual abuse. So concrete steps to materialize this meeting have to be set. For example, a meeting date and a meeting place have been agreed between the offender and the child, or for example, the offender arrives at the meeting place. In many cases of grooming nowadays, this so-called quote unquote meeting takes place online and it's not a physical meeting anymore. Instead, children are being sexually abused and exploited through the internet. Children are manipulated in producing and sharing self-generated sexual images. Hence, the current legal framework in many countries, not in all, but in many countries, do not reflect this digital reality. Organizations working in this field, fighting against child sexual abuse, recommend to extend this definition of grooming to sexual abuse committed online and not to limit it to the physical meetings. This is something that has already been enshrined in the EU directive on combating the sexual abuse and exploitation of children. This directive criminalizes the solicitation of children through online means for the purpose of persuading the child to send material with sexual content. So there is no need to have a physical, steps to be taken for a physical meeting. So this directive really reflects the digital reality we are living in. All right, let's come to the second example that I have. So that's sexting and self-generated sexually explicit material. So this material is self-produced consensually and is practiced often among children or also adults who derive pleasure from that and produce and share material with consent. The volume of self-produced sexually explicit material of children circulating online is increasing. More and more children explore and express their sexuality in the digital world by generating sexually suggestive or explicit images or videos with peers. This might not always have repercussions. However, sometimes such material is circulated further with or without the consent of the child and might be exploited by sexual offenders. Moreover, there is a lack of clarification about the legal status of sexting in many countries. Only few countries have legislation in place to deal with self-generated sexually explicit material of children, which have been produced in a consensual framework. In some countries, children are even punished for sharing and possessing child in the legal framework, often called child pornography. They're often punished for sharing and possessing this material for consensual sexting. This is a paradox because CSAM legislation is there. The intention of CSAM legislation is to protect children. And in some countries, this might even result in children being arrested for consensual sexting. All right, I want to move to the current EU policy debate now on child sexual abuse material, which is also a lot on child rights and privacy rights. So in May last year, so 2022, the European Commission, the DG for Migration and Home Affairs, published a proposal for a regulation to prevent and combat child sexual abuse. This proposal raised a big outcry of mainly digital rights organizations, but also others, criticizing the content of the proposal. The debate on the effectiveness of the proposal, but also children's rights and the right to private communication flared up. Before I bring forward these arguments for the proposal and its criticism, I want to very briefly summarize the content of the proposal. The proposal aims to combat the online dissemination of child sexual abuse material and online grooming. The proposal introduces a legal obligation for online service providers to detect, to report, and to remove child sexual abuse material on their platforms. And moreover, this proposal also foresees the establishment a new independent EU center on child sexual abuse that should be established and should support online service providers and also national law enforcement actors to implement this regulation once it's being implemented. It should also support, this EU center should also support member states and also victims. I want to come now to some selected reasons that speak for the proposal. And afterwards, in my next slides, I'll come to reasons of criticism that has been raised by various stakeholders on the proposal. So, as I've already mentioned before, within the last years, and also since the outbreak of the pandemic, there has been a tremendous increase of CSAM, child sexual abuse material, circulating on various online platforms. And in light of this volume, the majority of this material goes unreported. So there is clearly a need to address this increase of material online. The current system foresees a voluntary detection and reporting by private companies. Accordingly, this voluntary action, my voice. So the current system that is in place foresees a voluntary detection and reporting by private companies. And accordingly, these voluntary actions are insufficient, because there are some providers who are more active, and on the other hand, there are some providers which do not cooperate and are not so active in that field. And this leaves loopholes for undetected distribution of CSAM. A lot of CSAM is also shared with end-to-end encryption. And for this reason, the proposal foresees to also address encrypted data as well. When it comes to the EU Center on Child Sexual Abuse, this new center that should be established, this should bring improvements. On the one hand, this centralized organization will should streamline the process. So there won't be a need to send files to several authorities. This will be streamlined through one organization. And also the better coordination between online service providers, public authorities, and civil society organizations are needed, or are on the one hand are needed and also should be provided by this center. Sorry, I have to. So let's come to some of the arguments that criticize the proposal. So the main criticism is that it infringes fundamental rights, and mainly the right for private and family life, which also entails the right to confidential online communication. It's enshrined in Article 7 of the EU Charter of Fundamental Rights. This article also means that communication, online or offline, are presumed innocent unless there is reasonable, justifiable suspicion against that. So intervening in someone's private communication has to be targeted and to that very specific individual, and also a balancing test on necessity and proportionality needs to be conducted. So a general scanning is actually not allowed. Moreover, encryption is also, this is one of the major criticism in the proposal as well. Encryption is one of the few tools for confidential online communication. And the scanning of end-to-end encryption communication without a justifiable suspicion is something that worries many digital rights organizations. Yes, and very briefly to encryption. Encryption is something that encrypted messages can be read only by the sender and the person or persons where this message or this data is meant to be read. So no one in between except the sender of the message and the recipient of the message is unable to read this message. And the proposal also foresees to that kind of a backdoor is included in this encrypted communication. So then, if needed, then this data, this encrypted message, can be screened. Moreover, there is a high number of CSAM is exchanged over darknet forums. So some darknet forums are especially dedicated to the exchange of CSAM. And of course, this proposal does not, so the providers of darknet forums are outside of the scope of the proposal. So the proposal would not address one important source of CSAM. Criminalizing consensual sexting between adolescents could also be an issue that is raised if the proposal is implemented in the current version. The EU directive on combating sexual abuse and exploitation of children allows non-criminalization of self-generated CSAM. It allows the production and possession of material involving children who have reached the age of sexual consent, where that material is produced and possessed with the consent of those children and only for the private use of the persons involved. So so that this act does not involve any abuse. So this means that also the implementation of the proposal could raise some conflicts with this non-criminalization of sexual sexting. Furthermore, also there have been raised some practical concerns as well. For example, it will create a big bureaucratic burden to court administrations to implement the regulations, and particularly for Ireland, where many online service providers are located within the EU. I want to come to my conclusions on the debate to summarize this. The proposal follows a legitimate aim to decrease the online dissemination of CSAM and to protect children from online grooming. So consequently, to protect children overall within the online world. According to the criticism, the proposal is disproportionate and not effective in reaching the aim of protecting children. What I can say is now is that the proposal is at the moment in the consultation phase and is now with the European Parliament and the Council of the EU, and they will take the feedback into consideration and decide on the proposal. Okay, here I will stop with my presentation, and I'm very happy to address your questions in the Q&A session.
Thank you very much, Jimmy, for this very, very clear presentation of some of the legal challenges that the legislators are facing when it comes to these crimes that have an online element, and also presenting these the reason of the EU proposal and the criticism of some digital rights organizations. I find that that debate actually fascinating. And I think it will, should it pass in the current form, it will affect all of us in a way or another, because rules will change on the internet in general. But from this legal discussion now, let's move to our next panelist, to a more sociological and psychological analysis of the issue at stake on the trauma bonding in human trafficking and child sexual abuse online. So Nadine, the floor is yours.
Hi, everyone. I'm very glad to talk about this very important topic here with my panel. Thank you, everyone, for being here, and thank you, Madalena, for this introduction. So this research has been conducted under the HEROES project, and it's conducted to aim to provide better assistance to victims of human trafficking and child sexual abuse online. So we will shift our perspective now from the legal and policy side to a more social debate. So human trafficking and child sexual abuse in general, whether offline or online, are very serious crimes that impact the lives of victims. They are human rights violations that can lead to many physical and mental health consequences as a result of maybe pre-existing vulnerabilities that the victim might have, and their violation of human dignity. Now, while not all victims of these crimes can experience some mental health consequences, a lot of them might be traumatized from the experience and eventually might have some trauma related to their relationship that has been developed between them and the perpetrator, which can be their abuser in case of child sexual abuse. So this relationship has been characterized as a very complex one that develops between the perpetrator and the victim, and the literature has called this a trauma bond. So what is trauma bonding? Trauma bonding is an attachment bond that is created or developed by the victim towards the abuser. It's a relationship characterized by periods of abuse, violence, and power imbalance as a result of intentional emotional manipulation practiced by the perpetrator towards the victim, where the abuser might alternate between positive and negative behaviors, which are called also as psychological coercion techniques that we will go into a bit later on to explain what they are. So others have also considered trauma bonding to be a coping mechanism or a survival strategy, where the victims develop it in order to cope with the abusive situation, to accept it, but at the same time, they start to sympathize with their abuser and develop some kind of an emotional bond towards them. So what happens here? Here, there's a creation of an intense connection with the abuser. They depend on them for every basic need that they have. And they start, instead of feeling victimized, they feel indebted and grateful towards their abuser. Now, it's very important to mention here that trauma bonding is not just confined in human trafficking and child sexual abuse. It also can result from hostage situation, kidnapping, domestic violence, etc. So we have talked in this panel since it started how the internet has facilitated the increase of commission of crimes online. So human trafficking and especially child sexual abuse offenses online have become such a harsh reality that needs to be addressed. The internet has become a common place for everyone to meet new people. So children, adolescents, everyone uses the internet and social media to interact with other people. So grooming victims into these crimes have become much simpler than in the physical world. Since the internet gives a lot of advantages to perpetrator, they start using social media platforms to identify, lure, and recruit many victims easily and simultaneously using these online services. So it creates an atmosphere where the perpetrator can have consistent and easy contact with multiple victims at the same time. They can also create fake accounts and profiles that may relate to the victim that they are talking with in order to build that relationship. Now, Since trauma bonding can occur in victims of human trafficking and child sexual abuse in the physical world, let's say, the question here is, do victims of these crimes committed online develop this kind of emotional bond towards their abuser by just contacting them online? So we have, in the phase of this research, we have conducted 7 interviews with 8 participants that work in the field of assistance of victims of these crimes. So people who are experts in psychology, therapy, social work, and counseling, and also investigation of these crimes. Now, let's start from the big question. Do all of these victims experience a trauma bond? The question is no. Not 100% of the victims of these crimes develop a trauma bond towards the perpetrator in general. The majority of them do. However, it depends on many elements, including the vulnerabilities of the victim. That means their past experiences might also play a role of how susceptible they are to develop an attachment bond towards their abuser. That means also that their cultural background can play a role in this. Another thing that adds to it is the maturity, the emotional and psychological maturity of the victim. Another thing is that the grooming process has to be successful in order for a trauma bond to take place. So if a perpetrator cannot establish this bond through the grooming process, he might try to reestablish the relationship with the victim or go to another victim and start new. So why not all victims also experience a trauma bond is that because sometimes when big organized crimes that commit these type of criminal acts and where there is corruption, for example, the victim might not experience some kind of emotional feelings like love, friendship towards their abusers, but instead they just fear them. So this is a case where they do not have an attachment bond towards their abuser. So let's move to psychological coercion that I have talked about in the beginning. So here we can maybe divide the psychological coercion in 2 phases: before the abuse and during the abuse. So coercion in general term is the ability of the perpetrator to persuade someone to do something or give them consent by using deception, threat, and force techniques. So before the abuse, I have talked that the vulnerability of the victim plays a huge role in this, and past experiences like childhood trauma, where the victim has not been treated for that trauma before, might increase their chances of being abused and developing this trauma bond towards the perpetrator. So the perpetrator actually feeds on these vulnerabilities. So they use these vulnerabilities in order to create a conversation with the victim, in order to show them affection, love, and having the victim trust them. What we have seen, unfortunately, these days, that how the lover boy phenomena is increasing. So the lover boy phenomena is defined where a lover boy, who was also a pimp, who lures on victims, young girls and boys who are maybe in difficult situation, are in need of someone, an adult, for example, to be in their lives, and they start to build this romantic relationship with them. So they start to sending them gifts, showing them love, maybe even sleeping with them, in order to build that romantic relationship with them, because they know that eventually the victim will be attached to them and they will do whatever the perpetrator wants. So after having this kind of relationship being established a bit, the perpetrator starts manipulating and controlling the victim by alternating between violent and non-violent behaviors in order to gain cooperation. So violent behaviors might be anything physical, that it might be even having them addicted to drugs, having them, raping them, beating them, etc. Non-violent behaviors might include isolating the victim from the outside world so that the victim have no one else to go to except for the perpetrator. This is called also the carrot and the stick method, where the victim is constantly being rewarded by these maybe gifts or feelings of love and affection towards them when they do something that pleases the perpetrator. Now, it's important to see that these kind of psychological coercion techniques can be used also online. We have talked about how it facilitates the commission of these crimes. So unfortunately, the first contact of some victims nowadays might be online with the perpetrator before a physical meeting takes place. They might not even be physical meetings, as my colleagues Jimmy and Margherita have already said. So they might, the perpetrator can use the internet to create bonds online and gain trust much faster than in the physical world. So grooming victims by the use of technology such as social media and other online platforms could eventually lead to a trauma bond. It still depends on many factors. So not all victims might develop it. Now, I have already talked about the grooming process that needs to be successful in order to develop a trauma bond. So grooming of children from a social perspective is defined as the process during which a person builds trust and emotional connection with a minor in order to manipulate them and abuse them more easily. And in online contacts, grooming can happen, you can say, on 5 levels. The first level is when the perpetrator starts identifying and targeting young persons based on their social media content. So basically seeing their profile picture, their comments, their tweets, for example, what they post as stories. So they know what is the personality of the victim, what are their vulnerabilities and problems in life if they post it, for example. And accordingly, they might create fake profiles that relate to that victim. So, for example, an old man can create a fake profile of a very young boy or girl that has the same age of the victim, and they will start the conversation with them on that basis. So, important to say here that the perpetrator usually asks the victim to keep the online conversations private, meaning that do not talk about this to anyone else. This is a secret between you and I. So in this way, they isolate them from the outside world, again, to have them go back to them for everything, such as we have already talked that can happen in these crimes also in the physical world. So based on this conversation and the information collected from the profiles of the victims, the perpetrator can start showing behaviors of admiration, affection, or building either a romantic relationship, a friendship one with the victim, where they maintain constant and consistent presence in their lives. And this is how the internet makes it so easy. You can text anyone at any time. The child that can log off for one night and wake up seeing that the perpetrator have left them a sweet chat, for example, or a gift. So there is also a consistent presence of the perpetrator in the life of the victim. So by time, a trust starts to be built between the two parties and the victim starts bonding with the perpetrator. Now, it's very important to mention that when it comes to child sexual abuse, some victims might not have been ever exposed to sexual content. So they don't know what that means. They don't know what child sexual abuse material means. So the perpetrator can start slowly introducing this content to the child by sending them child sexual abuse materials of other children, for example, some videos that contain nudity, pornography, etc. So they use coercion and deception techniques, maybe even threats, to have that child engage in a sexual activity after introducing them to that. And here is what I talked about, the carrot and the stick method in the psychological coercion phases, where the perpetrator can feed on that relationship that they have created with the victim in order to have them send some kind of sexual material, maybe a picture of themselves nude or anything else that can be defined of CSM. So here the child can be rewarded by sending this kind of material to the perpetrator, by the perpetrator sending them gifts or building more and more that relationship with them. So showing them love and affection, for example, and they start controlling the victim. In this context also, the perpetrator might engage in what we have explained before, sextortion, which is, if you don't send me this picture, for example, I will distribute what you have sent me on the internet, for example, without the consent of the child. So it's a consistent loop where the victim is stuck in, where the abuse continues to take place, and where not just, despite the abuse happening, the child might not see that they have been abused or victimized by it, but instead their perception of what a normal relationship is in general is distorted at that stage. So the psychological coercion techniques can happen online. So a trauma bond can be easily created in the online context also. That means that the perpetrators nowadays have unfortunately developed these kind of techniques and strategies that enable them to online groom victims easily than in the physical world. So as to conclude, it still depends on many factors to have a trauma bond develop in child sexual abuse and human trafficking online. It still can occur, but not the majority of these victims can develop it. It depends on a case-by-case situation, the vulnerabilities of the victim and their past experiences. So how susceptible they are to fall in the trap of the perpetrator. It also depends on the successful grooming process, if it was successful or not, and how the perpetrator engages in emotional manipulation with the victim. Unfortunately, as I said, the internet continues to be a place where easy access to these victims is very simple, where the creation of fake identities and consistent contact with the victim may lead to a development of a trauma bond with the perpetrator, and it might be a gateway for a physical meeting or might just stay online. So this is all from my side. Thank you. We'll be awaiting for your questions.
Thank you very much, Nadine, for this very interesting presentation and bringing it to the more concrete. So what does this mean from one perspective, at least for people affected by these crimes that have an online element? So I would be now curious, because in the HEROES project, in other strands of the research, we looked at the challenges when it comes to criminal proceedings. So once these crimes are being detected, what happens then in terms of victim participation and access to justice and so on? So from this perspective, how would you say that when this happens, when trauma bonding happens, like what would be the effect that this has on victims' participation in criminal proceedings? Do you have any data on that, or what is the current debate there? Thank you.
So in general, victims of these crimes who have developed a trauma bond don't really seek the help from the police for a lot of reasons. It might be related to their trauma bond because, as I said, their perception of being victimized is distorted. They don't see themselves as a victim from a first perspective to go and report that they have been abused or trafficked, for example. They also feel grateful and indebted towards the perpetrator. So for them to go to the police and actually talk about this crime and this person hurting them is hard to establish. However, in case criminal proceedings have started, let's just say that the police is aware of a case where there is a victim of these crimes and they have developed this kind of trauma bond. So we have seen that the cooperation of these victims with law enforcement cannot happen on a first instance. It needs a lot of support, it needs therapy, and it needs a lot of assistance during their talk with the police, because it might be hard for them to talk about the abusive situation. Also, considering that they have been traumatized, they might also not remember some memories of the abuse. Some kind of details will not be 100%. They might change their talk every single time they talk with the police. So it's important also here to say that law enforcement agencies and other stakeholders, when we have done this research, there is a lack of awareness on the topic of trauma bonding and how it affects the cooperation of victims with these stakeholders. So it's important to say that there is a specific approach that the police and other stakeholders working with these victims that they should adopt when talking with them in order to have them cooperate more and to avoid re-traumatization at the police station also.
Yeah. Thank you so much. There is a question raised also on this topic, so I'm putting you on the spot, Nadine, but then we will move on with other interesting questions. Do you have any resources to share about questioning or talking to possible THB victims, not only children, that are mindful of trauma bonding and give advice on how to tackle it during an interview? I believe it refers to the support that is in practice provided to victims which might have gone through trauma bonding.
So thank you for your question. So yes, I have a bit of information about this, not in detail, but for example, for service providers who are in contact with victims of these crimes, there are protocols that they use in order to approach these victims and talk with them. There are specific terms that these service providers should not use with the victims or avoid using them, such as telling them that you are a victim and this person is an abuser, or being judgmental. So being non-judgmental with the victims and listening instead of talking is very important. On the other hand, it's very important to say that NGOs or people who work in counseling with these victims develop an individualistic approach or therapeutic program specialized to these victims depending on their background, their culture, and their case where they have been abused. And depending on that, they start the, let's say, recovery process with the victim. I hope that answers your question a bit. What I can say is once this research is public, I would invite you to take a look at it because it will be more in detail. We will talk more in detail about how to better assist these victims with the help of service providers.
Thank you. Thank you, Nadine. I would just like to pick up on something that was mentioned, that the nature of some offenses is changed due to the online element. And I would like to ask any of you, but I think you mentioned that, Jimmy, in your presentation. Would you agree that the online facilitation of exploitation in general and of child sexual exploitation in particular changes the nature of exploitation itself? And if so, or if not, is there a need for a paradigm shift, if you wish, in how we look at exploitation?
Thanks for this this question. It would require an analysis on that. I don't fully agree that the nature of exploitation has changed. It's true, it has created new aspects. So this online dimension has created new aspects. For example, so also referring to Margarita's presentation and my presentation, when it comes to grooming, this that the meeting might not take place offline anymore, but happens online. So these are new elements that have to be introduced also or the elements of the criminal offense needs to be adapted to that to also reflect this reality. And on the other hand, there are new forms of abuse, of exploitation, but some of the forms of exploitation have still remained the same. For example, if a child gets sexually abused and this abuse is live streamed, it's still an exploitation that happens offline. But now there's a new channel of consuming the CSAM by people and in real time watching the sexual abuse. So it's a new channel, a form to watch that abuse, but I wouldn't say it's a new form of exploitation. And also, if you look at it from the child's perspective, this child is still being abused offline, even though there's this new online element that people from various places of the world can watch the abuse. That's a new aspect, but still, when you look at it from the child's perspective, or also from adults, the abuse is still taking place in the real world. So often, I think, yeah, as I mentioned at the beginning of my presentation, I think we should not put the phenomenon in two boxes, in online and offline offenses. Very often it's a mixture of both. So if someone is abused and this is also facilitated online, this is also an offline abuse. Yeah, it's often a mixture of that.
Thank you. I suppose that the question on the paradigm shift with regard to addressing exploitation requires more of a philosophical discussion, and I think, yeah, we could we could start thinking of that if that is expected to have that in the new approaches. But from a more classical approach when it comes to crimes, it has been argued that increasing the penalty might lead to deterrence. So I would like to ask you, Margarita, from your experience, to what extent increasing penalties for child sexual abuse, so in the countries where this exists, right, will contribute to deterrence?
Thank you for this question, Madalena. Okay, I think we all agree that sexual exploitation of children is one of the worst forms of violence that we can know. That's a real violation of the fundamental rights of the child. We also have seen in this panel, and we all know that this child sexual exploitation has many phases. It can be child sexual abuse, it can be offense concerning child sexual exploitation, producing or distributing child sexual abuse material, corruption of children, offenses concerning the participation of children in pornographic performances, or even the solicitation of children for sexual purposes. So there's a wide range of actions, and they are not all the same. So, and they don't weigh the same. They are not so, they don't show the same lack of value, but because there are one that are worse than other, and that is shown in the penalties. So you can see different penalties for different actions, and that is good. That means that they are proportionate, because they searched to be effective and dissuasive at the same time. You cannot put the same penalties for different actions, because at the end it doesn't make any difference. So the perpetrators will try to do the worst, because it doesn't matter if they do one thing that is less important. Okay, thus it means that the penalties at this moment are not enough. Well, I think the penalties that are in different criminal codes are enough, because they follow the proportion that is set on the directive, and it also usually follow the proportion that is mandatory for each criminal code. So, shall we ask ourselves if higher penalties would mean less crimes? I don't think so, because when you reach some point, the penalty is not useful. It doesn't have it is not useful to deterrence. It is only useful to retribute, to give an answer to the crime, but not to prevent the crime. There are many other instruments or measures that can be used to deter the crimes. I mean, it is not only, the weight's not only increasing the penalties, many of them are already really high. So now thinking about it, I would think about two other measures that don't have to be with increasing the penalties, that maybe would help, or I'm sure are helping against these crimes. First of all, as is settled in this Lanzarote Convention, the introduction of this register to collect and store the data of the identity and the genetic profile of the person convicted of these offenses. I think this a very good. It could be a very good measure, and it could help to deterrence more than a higher penalty, because they can be sure that they could be caught. In Spain, this register also helps or contains such information to prevent the access to different professions or jobs involving to work with children. So I think that could be more helpful. And secondly, for example, it is good to insist on the measures to confiscation and seizure of the proceeds of crime. And I think this is a very good way, because since the last year, the crime policies are working on the basis that crime should not, or crime should pay. So maybe those policies are more effective than increasing the penalties. That will work better. They often offer a more powerful incentive not to commit crimes than the imprisonment. So I think not always making penalties higher will help to deter the crimes. Other measures, and of course, always, I think we still have to work beyond the tools of criminal nature. I mean, we have to work, or we still have a long way in the field of prevention, awareness raising, and training of the stakeholders involved. So with all those measures, I think will be better than increasing the penalties.
Thank you, Margarita, for this comprehensive answer. Indeed, this is one of the conclusions of the HEROES project as well, of research conducted in the HEROES project. We have 2 minutes left, and there is one question in the chat, whether there are any indications that the organized criminal behavior perpetrated by actors working in concentrated efforts, or is it mostly an individual crime perpetrated by individuals when it comes to child sexual abuse? Jimmy, would you like to?
This?
Yeah.
Yes.
Briefly.
So I don't have numbers on the top of my head on that, and I'm not aware of statistics on that. But what we know from research is definitely that the majority of child sexual abuse happens in home or by someone who's close or known to the young person. So it's not very often, it's not a criminal network that conducts the abuse itself. Another issue is the dissemination of material of abuse that has already been conducted. So there is definitely
thank you,
yes,
Jimmy.
I'm looking at the time.
Yes. We have less than a minute left. Thank you so much, everyone, for the questions raised. Thank you so much to the panelists and to this